First and foremost, for the introduction, we refer to Section 8 of the Evidence Act 1950, which provides the evidence of facts demonstrating the motive, preparation and conduct of persons involved in a crime if such conduct influences or influenced by any facts in issue or relevant facts. Here, evidence demonstrating a motive, preparation or conduct must be provided directly by a witness who witnessed it. In brief, motive describes the cause of why a person performs a specific action, while an act of preparation means that any action that leads to the commission of a crime or facilitates the commission of a crime. An action specifically is referred to as conduct. Evidence concerning past or subsequent actions of the accused person, victim or a third party may be submitted as evidence under the Evidence Act of 1950.
Motive is the reason why a person commits certain act. It is different from intention, where a person directly intends those consequences that he desires to bring about by his own acts. This can be supported with the case of R and Veen and Lower Perak cooperative cases. Next, the existence of motive. In general, the absence of motive is not relevant in law, as motive is not an element in criminal cases. However, it is admissible under Section 8 of Evidence Act 1950. If there is no motive, it does not in any way reduce the accused's guilt for committing the offence. This can be referred to Rajinder Kumar, which stated that the guilt of the accused Rajinder is however not weakened at all by the fact that the motive has not been established. It often happens that only the culprit himself knows what moved him to a certain course of action. Next, the absence of motive also does not constitute that the accused is innocent. This is because when there is a direct evident and clear proof that the accused has committed the crime, the question of motive for maintaining the conviction becomes irrelevant. Yet, when a case depends entirely upon circumstantial evidence, the issue of motive becomes crucial, as in Public Prosecutor against Peter Kong. Therefore, in what situation does motive becomes admissible under Section 8 has been illustrated in illustration A and B. For A, it is when the evidence that suggests the accused is of bad character or he has committed some crime other than the one with which he is charged is admissible in law. Meanwhile, for B is when it involves money where the crime is financial. An accused is said to have a motive in requiring money for himself. For instance, he commits crime by extortion. The decided cases that can be referred to for these two illustrations A and B are Wong For Hin against Public Prosecutor and Lim Kong against Public Prosecutor.
Section 8 Clause 1 of the Evidence Act provides that any fact is relevant which shows or constitutes a motive or a preparation for any fact in issue or relevant fact. Preparation on the part of accused may be to accomplish the crime, to prevent its discovery or to help escape and avert the suspicion from himself. This means any action or act which leads to the production of the crime or facilitates a criminal action such as collecting, purchasing, repairing something amounts to the preparation of the crime. Next, I'll be explaining on the cases of preparation. In the case of Tangia versus Public Prosecutor, crime has been classified into 4 stages. Firstly, the intention to commit the crime, then the preparation of the crime, thirdly, the attempt to commit the crime, and lastly is the commit of the crime which has already been an offence. According to this case, the first 2 does not amount to crime, yet the moment it has been attempted is where the offence occurs. Besides, in the case of Ta Ben Chia versus Public Prosecutor, the accused took the complainant to some bushes and removed his shorts and inner pants. The accused was convicted of an attempted rape. On appeal, the court held that the evidence was insufficient to constitute an attempt to rape. Hence, it has been stated that the mere act of planning to commit the crime and establishing an intention to do so are not crime, and it is not subject to legal punishment. Lastly, preparation is the initial state for committing any crime. According to Sir Henry Maine, preparation consists of arranging the means or measures for the commission of an offence. It is clear that preparation does not amount to crime, but is a crucial element that may establish why a person commits a crime. Thus, according to Section 8 Clause 1 of the Evidence Act, preparation is a pertinent and admissible in establishing the necessary fact.
Conduct refers to the particular way in which someone behaves. explanations in Section 8, Clause 2 provides the on how statement becomes conduct and how conduct becomes relevant. This can be supported in the case of Buta Singh and Public Prosecutor, whereby McFall J was in view that the report was rightly admitted as evidence because the accused's action towards the disease had caused the disease to make a police report. In regards to the relevancy, conduct in question must directly affects, influences, or is affected by the facts in issue. Meanwhile, Saka on evidence stated that a fact in issue must directly affect or be immediately affected by the conduct. In the case of Chandra Sekaran and others, and Public Prosecutor, conduct is admissible under Section 8 if the said conduct was seen to support the guilt of the accused. Meanwhile, in the case of Abdullah Zawawi bin Yusuf and Public Prosecutor, the act of simply running away or attempting to run is inadequate to incriminate the accused. In the case of Arif Arhanan Cik Udin and Public Prosecutor and another appeal, the fact in issue was whether the appellant had the knowledge of what was in the black bag. Appellant's conduct of picking up the black bag and giving it to SP6 was clearly relevant to the issue. Conduct of the appellant picking up the black bag, which was hidden between clothes himself, shows that he has knowledge of the drugs. In the case of Shohel and Public Prosecutor, conduct of the appellant showing the axe which was under the plywood on the 10th floor of the building, which was still in the construction during the incident, is relevant and is admissible under Section 8, Clause 2. Conduct of the appellant shows that he has knowledge and location of the acts, and it shows that only the accused would know the exact locations of the acts, and therefore the conduct of the appellant is relevant to the facts in issue.
Explaining regarding to the previous conduct and subsequent conduct, which stated clearly under Section 8, Clause 2 of the Evidence Act, together with illustration under subsection A until K of the section. In the previous conduct, the conduct can be defined as the accused conduct before the commission of the crime, which is also can be considered as a preparation. For example, a person ran a boat for the purpose of a crime which he intends the victim to be die of drowning. Secondly, in the subsequent conduct, it can be defined as the action of the accused, victim, or the third party after a crime is committed. For example, the person is crying, running, or maybe frightening after the crime can become a subsequent conduct. In the previous conduct, it is stated clearly under Section 8, Clause 2 with the illustration C, D, and E, whereby for illustration C shows that A procured poison similar to he was administered to B before B's death. This shows that the act of A performed before B's death is crucial. For example, in the case of R against Ball for the incest case, whereby the past sexual relationship of the parties can conclude a previous conduct for the incest case. Moreover, this can be supported by the Ravindran case for example, for firearms matter, the complaints has been lodged numerously on accused can be defined as a previous conduct that supports subsequent conduct of the accused. Next, in subsequent conduct, generally it is under illustration E until K of the section 8. However, in illustration H states clearly the admissibility of a content due subsequent conduct can be done. As example, in Buta Singh case, the court held that the statement is inadmissible unless it is supporting with any act of the accused. Next, in illustration I states clearly that after the crime act, such as ops conduct, under the case of Parla Dade, the accused has stepped back and shot once being stopped by police, shows the guilty mind of the subsequent conduct.
Evidence of conduct can be in many forms, and one of it is a deliberate lie. A deliberate lie can be constituted as an evidence of conduct under Section 8, admissible in court, if it's fulfilled the requirements. And there were 4 requirements where we refer in the case of Koo Koon Hein against Public Prosecutor, provided these requirements. And the requirements were a deliberate lie, a lie that has connection with the immaterial fact of issue in that case. Third is that a lie that have a sense of fear or a guilt towards that person, the mens rea of that person. And lastly, a lie that can be corroborative or independent evidence. And this requirement can be applied in another case, in Malaysian case, which is Muhammad Abbas bin Danus Paksan, where the fact of the case is that the accused has made a deliberate lie that he has not seen the girl. However, it is impossible to say that he did not see the girl at all, while both of them were in the same area. And in the same case, the judge and the court held that the deliberate lie made by the accused, who is a guard, is an evidence of conduct admissible under Section 8 of Evidence Act as an admissible in the court and can be used
as an evidence that contribute the value of being corroborative evidence.
In conclusion, motive, preparation, and conduct hold a significant role in the commission of any crime. Even if it is inconsequential or does not take a big part, the court takes great care to consider it, and only after reviewing all of the facts and evidence before it reaches any decision. Thus, motive, preparation, and conduct are essential in any specific criminal case and contribute to arresting the accused for his or her involvement in any crime of the case. That is all from us. Thank you.